We all know that a handshake agreement is unenforceable when it comes to purchasing property, but what about a handshake agreement to modify a written property agreement? Generally, the statute of frauds would kick in, requiring even that modification to be in writing. However, in the Arkansas case of Johnston versus Curtis, we examined the applicability of the statute of frauds when partial performance of a contract is also present. In October of 1997, Gerald and Bebe Johnston entered into a written contract to buy Glen and Deanna Curtis's home in Cabot, Arkansas, for $114,000. The contract was subject to the Johnstons' ability to obtain financing for 90% of the purchase price. After the contract was signed, the Curtises purchased a new home in Searcy and moved out. When the Cabot house was later appraised for $110,000, the Johnstons were unable to obtain a loan for 90% of that $114,000 purchase price. The parties orally agreed to reduce the purchase price to match the appraised value of the home. The Johnstons' loan for 90% of the new purchase price was ultimately approved. Prior to closing, the Johnstons took early possession of the Cabot home, moved in, and gave the Curtises a check for $500 to hold until closing. On November 17th, the date set for closing, the Johnstons declined to move forward with the home purchase. They claimed that the interest rate was too high and that other terms of the loan were unacceptable. The Curtises then listed their Cabot home and later sold it for $100,000. The Curtises sued the Johnstons for breach of contract, and the trial court awarded the Curtises $10,000, which represented the difference between the actual sale price and the $110,000 purchase price. The Johnstons appealed to the Arkansas Court of Appeals.